And we're live.
All right. This is Senate Judiciary. We're going over an amendment to a bill on pharmacy benefit managers. And you have a number of things posted. It was discussed in the Senate Appropriations Committee yesterday, and Jen has been kind enough to draft an amendment to that bill that would be offered on behalf of myself and anybody else. The problem, as I see it, is once again, we've added a private right of action for pharmacies to go after pharmacy benefit managers. There's a lot of concern about this, that it will raise health insurance costs, as well as raise the cost of prescription drugs. So it's a very complicated bill, which we do not need to get into. But there is a section, and Jen may speak to it, which allows suits and other things by the independent pharmacies. And I think those sections would fall into place. And next year, we can come back and see if this sort of private right of action is going to be necessary. So that's my brief summation of the bill, and I'll let Jen take over, and you can ask her any questions you want. I did not schedule the testimony because of the shortness of time, but there are documents from those both in favor and opposed on our page.
Hey, good morning. Jen Tarby from the Office of Legislative Counsel, and I think Senator Sears did a great job of kind of setting the stage for what this amendment is about. This is a bill on pharmacy benefit managers, and it creates a system for licensing them. They have not previously been licensed. They have registered, but not been actively licensed, and they would be licensed by the Department of Financial Regulation under this bill. The piece that Senator Sears is talking about is, if you happen to be looking at the as passed by House version, anyone, it's on page 13 of 29. It's in the middle of the new chapter on PBM, pharmacy benefit manager licensure. And in addition to the enforcement authority of the Commissioner of Financial Regulation, it does allow a pharmacy, pharmacist, or other person injured by a PBM's violation of the new chapter to bring an action in court for relief. Senator Sears' amendment would strike out just that subsection creating the private right of action, and then it would add a new section to the bill directing DFR, Department of Financial Regulation, to come back in January and report to the Healthcare and Judiciary committees regarding whether the department recommends enabling pharmacies, pharmacists, and others who are injured by a PBM's violation of that new chapter to bring an action in court. That is it.
So we're putting in statute that DFR is supposed to come back in January to make a report as to whether or not people can sue pharmacy benefit managers.
Right, so this wouldn't go technically in the statute, it would just be part of the bill. But yes, it would be a provision asking DFR to come back and recommend whether there should be a private right of action, whether individuals other than the Department of Financial Regulation should be able to effectively enforce the provisions of this chapter.
Yeah, this might be a question for DFR, but is there a reason they weren't able to make that testimony or report over the last couple of months when we were working on the bill, or the other committees were working?
I frankly don't recall if they weighed in on that provision. It has only been raised as a concern in the last couple of days, so I'm not sure what DFR's position is on it or whether they have been asked.
All right, well, okay, thank you. I don't see any other questions in the room, Senator.
Okay. So Jen, this would not be a committee amendment, but rather an amendment from myself. But if any other committee members wish to join me, I'd be happy to have that happen.
Sure, I'm happy to add any members who would like to be on. I will add Senator Norris. I'll add Senator Norris, and then I will send it back to you, Senator Sears, so you can forward it to the Secretary's office. Does that work?
That works for me.
Great.
Does everybody understand the issue? Could you just describe a little bit about what would be currently new in law regarding lawsuits or fines from DFR for any violations? I think it may make people a little more comfortable.
Sure. I mean, there are enforcement provisions in the new chapter for DFR, specifically that DFR would enforce compliance with the chapter. It gives them the ability to examine and audit books. It gives some authority to the Office of the Healthcare Advocate to receive reports when DFR does do an examination or audit. DFR has fairly significant existing authority to enforce all of the industry or provisions affecting the industries that it regulates. So this doesn't change. The private right of action is for others beyond DFR. So a lot of the issues that have typically come up in the pharmacy benefit management space are disagreements between pharmacies, pharmacists, and pharmacy benefit managers over the appropriateness of the payment, the timeliness of the payment, whether how audits were conducted, things like that.
And are those what's covered in Chapter 77? 18 VSA 77.
So Chapter 18 VSA 77 is the new chapter. It codifies in one chapter and kind of combines a lot of existing PBM regulation and provision, but there has not been a lot of enforcement authority. Has not been enforcement authority beyond DFR currently, other than on some other theory like a contract violation or breach of contract kind of thing, or a tort or something like that. This gives DFR more regulatory oversight and an ongoing licensure authority so that they can determine whether to renew a license and do examinations of the pharmacy benefit managers to ensure their compliance as DFR sees it with the provisions of the chapter. The question is whether anyone outside of DFR would be able to enforce.
So like if just a private individual, well, it's a private right of action. So if a private individual is harmed by a violation of Chapter 77, it would be DFR's responsibility to investigate and prosecute.
If somebody brought it to DFR's attention, yes, or if DFR became aware of it in another way. I think the issue I have heard about, and I know there has been litigation in the past, and anecdotally what I understand is that DFR has said it does not, it enforces consumer complaints. It does not investigate or enforce pharmacy complaints. Whether that would change under this bill with the new licensure mechanism, I don't know.
Okay. Everybody all right?
Do you have a question?
I have a question, but I don't know if Jen's going to be able to answer it. And that is really around like what is the harm that's happening to pharmacies and pharmacists that they currently have no recourse for. And I realize you're not really the right person to ask, but I don't think the right person to ask is in the room.
I mean, there are a few people in the room who have been part of this bill's journey throughout, representing different perspectives. So the Office of the Healthcare Advocate, Theo Kennedy represents pharmacists or Retail Druggists Association, pharmacists and pharmacies. Jamie Finn represents one of the pharmacy benefit managers that also operates retail pharmacies, CVS. So there are
people in the room who could answer my question,
who may have different perspectives on the answer to that question.
Yeah, if there's harm being done, I generally don't want to have anyone not have any recourse that they can take. So it concerns me that is the status quo, and we're kind of maybe sticking with that. I don't know if anyone wants to give permission to someone who can answer the question to do so.
Well, not without getting into allowing both sides to speak. That's why I had Ben post on our page comments from Jamie Feenan and others, as well as the gentleman in the room. I don't know if Jamie's there or not. So that,
Yes, Jamie is here. There's testimony. So there's testimony from the pharmacy benefit manager perspective on your webpage. I don't see anything, unless Ben has received anything else. I don't see anything from
I believe 3. So one from Jamie, and then Jeff. I'm gonna pronounce that wrong.
Huckberg.
Yep. That
Okay.
one.
Oh, okay. His just looks like it just went up. So, so he is part of the Pharmacists Association or for retail druggist. I'm gonna get him wrong. He is with a pharmacy. He's not a pharmacist.
Okay.
Thank you.
I don't want to hold the bill up, like I don't want to take this out, so I probably won't vote for the amendment, but I think the rest of the bill is important enough that I don't want to hold it up to get the answer to my question. But I do find it concerning that we have people that are being harmed that can't do anything.
well, but my understanding of the bill is that as it proceeds, and if it's signed into law, that they will have some more recourse than they have currently.
Okay.
And before we start a private right of action, from my perspective, that has not been fully vetted by this committee, wasn't even aware of it until 2 days ago. It's troubling to me. I mean, I would hope that in the future that other committee chairs would come to this committee if they're changing things that have to do with lawsuits. That's really my problem. And I'm happy to have this, if I'm back in January, I'm happy to have this be a priority once we have the report from DFR. But in the meantime, I think that the bill would provide some recourse. And if you look at Jamie Feenan's, and I realize he's representing CVS and maybe others, his email certainly indicates that from their perspective, that this would be one of the rare cases in the nation, and that it may have ramifications beyond what is intended. I'm always afraid of unintended consequences. So that's my reason for doing it.
I appreciate that.
Jen, do you happen to know how long the underlying language of the private right of action has been in H-233?
I believe it has been in the bill since it was introduced.
Is that this year or last
It's
year?
actually introduced last year, and I have to look to see if it was actually in. Yes, it was. It has been in since the bill was introduced in 2023.
And do you happen to have on the pages you're looking at what committees it went through?
Yes, because I've been in all of them. So it went to started in House Healthcare. It went to House Ways and Means, House Appropriations, Senate Health and Welfare, Senate Finance, and Senate Appropriations.
Okay.
That all of those have happened this year. It was not acted on last year.
Okay. Thank you.
I will only add that it wasn't until it got into finance that I even found out that it was in there. Senate Finance. One of the senators in finance just alerted me that it was there.
I'm not seeing any other questions in the room.
Okay, so I guess we're complete with that. Thank you very much, Jen.
Sure, I've updated the amendment. I will send it to you momentarily.
I want to just take up briefly S-259, the Climate Superfund Act. I've gone over the House changes. We can get a little more testimony on it if you'd like, but I don't know if Mike O'Grady's available this morning, but I think we should concur with the House. There's mostly just technical changes. I've spoken to the gentleman from the Conservation Law Foundation and others, and they're happy with what the House did. So.
Okay. Yeah, climate super.
I can't remember the gentleman's name because it escapes me at this hour. Yes, I believe it was. He sent me a side-by-side, which I could never find in my email again. There's so much coming in. So do you want to see if we do you want to see it
side by side? It's good for me.
Do you want to see if Mike O'Grady can come in briefly this morning, Ben?
Yeah, I can email him. We're just gonna be a little bit short on time because Ben Novogorski also needs to come in on 195 and Senator Gahovsky's amendment to 878. So
well,
I can see if
let's do Senator Wachowski's amendments to 858 since she's here and Eric's here. And the rest of the bill is will be on the floor.
Commissioner Morrison and Tucker are here to talk about a separate amendment. So do you want them to go first and then we'll have Eric come in?
Well, let's say that we and I'm happy to sign on to her crack cocaine repeal, and anybody else on the committee who would like to. So when Eric prepares that amendment, I'd like my name on it for the calendar and anybody else who would like to be on. I really appreciate your work on this, Senator Wachowski.
Thank you, Senator Sears.
So maybe you want to explain a little bit what it does.
I can do that. We briefly discussed this last week. This is the amendment that would eliminate the disparity in how different formations of cocaine are charged. So currently we have two different statutes, one that deals with powder cocaine and one that deals with crack cocaine, and those things are dealt with differently despite being the same drug. And so all this does not legalize or decriminalize anything. It simply makes them all fall under the same statute, which is the cocaine statute.
And the history of that, as far as I understand it, is that people of color were using crack cocaine, and many states tried to and generally people who were not of color were using cocaine. And the states seem to want to crack down on crack cocaine more than cocaine in terms of sentences, et cetera, et cetera. And that's really the history of it. And I think it's a good idea to get rid of that history. You can't get rid of it. I'm sorry. Let me start over. I think it's a good idea to get rid of anything that creates racial disparities.
Yes, I agree wholeheartedly. So that is the history, and certainly people have now come out and actually admitted that that's what they were doing at the time. So I think it's pretty important to align under one statute. That's the amendment. Simple little amendment.
So anybody who would like to sign on to that, let Eric know.
I will obviously sign.
Yes.
Well, Senator Wachowski goes first. Anyway, the second amendment from Senator Wachowski has to do with forfeiture. So I wonder if Commissioner Morrison or Tucker want to just speak to that briefly, and their proposed solution.
Good morning, Senator Sears. Good morning, other senators. Great to be back here, and I appreciate your hard work in the run-up to the end, the run to the finish line. So this might not be, my name is Jennifer Morrison. I'm the Commissioner of Public Safety. I have 34 years of experience in the Vermont law enforcement scene. This might not be my most coherent testimony ever provided because I just became aware of this amendment approximately 36 hours ago. So I'm here today to say that we oppose this amendment for a variety of reasons. First and foremost, in my mind, is that a report was delivered to this body in December of 22. 2 years ago, the House Judiciary Committee asked for this report, and a quite esteemed panel led by Chief Zone, and with participation from the Defender General's Office. Tucker represented the Department of Public Safety, the State Treasurer, the Attorney General's Office, the Department of State's Attorneys and Sheriffs, the Sheriff's Association, and the Center for Justice Reform at Vermont Law School were part of this report, which concluded that there were no recommendations for statutory changes about asset forfeiture. And this report you can certainly have, you can access it, I'm sure it's publicly available. So this issue has already been very well researched and concluded that there are no changes that are recommended. But specific to the language proposed in H878, when I read it through a couple times, and the first thing that came to my mind is, what is the problem we are trying to solve? I don't know what Vermont problem we are trying to solve with this. As you'll see in this report, the state asset forfeiture system does not get used. It's been used 12 times since 2015. It is not the type of things that people don't use the state system for things like drug cases, etc. It gets used in animal welfare cases sometimes, and stuff like that. It's a very, very rarely used state construct. So if we are trying to build a searchable public-facing database or an ability to search and candidly scrape data out of it, we would be building something for which nobody's coming. There's no input to put into it if the system is not being used. If we are trying to create something that captures the data of federal seizures, we're building something that already exists at the federal level. Forfeiture.gov already exists at the federal level. You can search by state and you can search by federal agency. And read their notices of seizures, etc. If we built it and populated it with federal case data, a lot of what's called for in this amendment, specifically 5, 6, 7, I believe it was 10 and 11, all of this information.
Can I interrupt real quick? Sure. Do we actually, Ben, do we have copies of this amendment?
So it's not an amendment. This is
part of the bill.
In the bill. It was voted out of the committee in section 54 and 55. So it's in the bill.
Okay.
It's on the calendar, on the notice calendar this morning, and was voted out.
54 and 55.
Correct.
Okay. Thank you.
Okay. Sorry. Yes. So did you get to where you wanted to? Okay.
Pretty much. Yeah.
Okay.
Thank you.
The highlighted version.
Yes.
The section numbering may not
Got
be
it.
right. It's the second. Should be the second to last section of the bill. The
The
highlighted version, section numbering is a little different. So go ahead to the very end. Wait. There you are.
Okay. Thank you.
On the highlighted version, it starts on page 50, page 60 if you're looking at the highlighted version.
So many of the chunks of information that are requested in this language would have to come directly from the feds. And anyway, I think that there is a fundamental confusion that would be caused by this, by sharing this information in this manner, and I'll explain why. If we seize something as part of a joint task force operation, which is pretty much how all these seizures happen, we aren't seizing them under the state system. They get seized because it's a case that's going federal. And let's say you work for Burlington Police and Senator Vyhovsky is a canine handler from another agency, and she gets called to bring her canine specifically to execute a warrant that results in a seizure. You're the case agent that's working for a task force. You're a deputized federal, task force agent, and Senator Norris's shop provides some other material support to the operation. All three agencies will realize a share of whatever is seized, the value of whatever is seized. The canine sniffing organization might get 5%. It's a formula of how assets are divided. You would get something because you were the lead agent on the case as a task force agent, and his agency might get something because they transported all the people back and forth from the scene back to the barracks or wherever it was going. Different levels of participation in cases that result in seizures result in a different share coming back to that agency. So under this construct, we would have the same case being reported, the same one federal case, because it's all a federal case. These are not cases that are being prosecuted at the state level. We would have it reported by multiple agencies in differing amounts, and I think that could lend confusion when in fact the largest portion of any of these seizures is going to be retained by the federal government, the federal agency that's leading the case anyway. So with that being said, if this were to go forward, there is an absolute must-have change in here. There's discussion of keeping information confidential if a CI, a confidential informant, was used. More importantly, no information about a seizure should be public until the case is disposed of. These federal cases are invariably done to flip further up the food chain into organized criminal enterprises and sometimes into international syndicates. So just disclosing that we've seized assets belonging to John Doe and publicizing that while there is still an active case would be terrible. It would be a terrible detriment to the ongoing investigation that could go on for months or years in some cases. So that would be a must-have change to this.
That makes sense.
Go ahead.
That makes sense to me,
Right,
adding that aspect in.
I'm sure there's a lot. I should have prefaced this by saying I'm not an expert in asset forfeiture. I have some experience with it as a police chief and in my current role, but even I could find that there was some concerns with this right out of the gate. In a nutshell, I think a lot of human resource and money is going to be spent to build something that is unlikely to further what I perceive the goal is of transparency. I gotta believe that's the goal of this, of transparency. I think that it's potentially more confusing. I would also call attention to the fact that agencies that realize proceeds from seized assets already have to file annual paperwork that is able to be FOIA'd by any person who's curious what's going on with asset forfeiture. And then I guess I will, come back to where I started, which is that 2 years ago, it was requested that a very robust and well-balanced working group take a look at this very topic, and they did. And they came back, this is what I would say is the authoritative version of the current status of asset forfeiture in Vermont, and they indicated that there were no recommendations needed. Lastly, I would say, when I read through this, there was nothing Vermonty. It doesn't mesh with how business is done in Vermont. I recognize that asset forfeiture has been problematic in other regions of the country. I think those days are gone because the feds have really tightened up their checks and balances in the asset forfeiture space. And perhaps there are states that do have a robust state asset forfeiture system. We do not use the state one. That is a fact. And I feel that this is not at all the highest and best use of DPS resources to put money and human resource into building and maintaining something with negligible value towards the goal of transparency.
Thank you. Senator Vyhovsky.
Yeah, you are correct. I am looking for transparency, and I know that we often use the equitable sharing aspect to sort of utilize the system. And I feel strongly, particularly because I know, I believe it was 2017 or 2018, that a Manchester police officer actually stole assets. I mean, it was $3,000. It was about, I think, like $200. It wasn't a ton of money, but like, I do think there are issues in the system, and maybe this isn't the finest way to do it, but we also, as a state, get a failing grade on the National Transparency and Accountability Report Card, particularly around forfeiture accounting. So I do want to build a system so that we're not getting a nationally failing grade on transparency. And if what it shows us is we're not really using this and this isn't really happening, I think that's excellent for people to know.
If the language in here was specific to use of the state asset forfeiture system, again, we'd be building something that we'd have no data to put into because it doesn't get used. However, at least we've gotten something to report it into if it gets used. If we're really trying to duplicate or more granularly expose how the federal system works, I think we could do it, but this isn't the way to do it. It's going to be confusing. Go ahead.
I believe Eric has a draft amendment to the amendment. Am I correct?
I don't have anything in writing, Senator Sears. I just found it. I noticed the discussion and said, was there a possibility that you would still get the goals of the bill without the website? Could you do the reporting? That was my only thought. Nothing in writing.
We probably could. I guess the sentence that I didn't properly finish was that there's a lot of sections of this language that don't really lend themselves to transparency. They're data points. Who cares about the federal docket number, except to be able to compare it, to I don't know what. But I think there's a way to get where you're trying to go, but this is not it, and it's going to be a lot of investment for what I don't believe it's going to advance the ball of transparency, but we can commit to helping you build something that gets where you want to go. And whether that's a report or a report that we eventually turn into a public facing, we have a data webpage that we could put something on. Maybe not in year one, because we got to build it and build something that makes sense, but I don't believe this is going to get you what you want. And I just wanted to make sure that we said that before this goes the rest of the final.
Thank you, Chief. I'm uncomfortable now after hearing this testimony with that amendment, but I would see if Eric can draft something that would provide more transparency. But given the small number of state cases, we dealt with forfeiture in the past, but there could be an avenue to at least have access to information.
Yeah, if there is a way to draft an amendment that starts moving us along on the process, and I'm happy to work with the Department of Public Safety to get us to where I want to be. But I would be supportive of something in that starts us down that path, and to come back and sort of finish going down that path next year.
Okay. Well, we got about 12 hours.
I know. We might have like 24. Who knows?
Who knows? At any rate, we have to get it back to the House. So, Eric, did you have anything else?
About this?
About the miscellaneous judiciary bill?
Well, there's the other amendments that are on the calendar.
Right.
There's two senators here having to do with, there's one technical amendment, it's just a minor grammatical change, as well as the other one about remote psychiatrist testimony and competency hearings.
Right. That's.
And then there's the one that was voted out by Senate Finance yesterday on,
right.
On the enhanced life estate deeds that the tax department agreed to. So I think that one's okay.
Yeah, that we will be agreeing with, well, I'll be agreeing with Senate Finance on their amendment. I don't like it. I don't like giving up what we had, but at any rate, this is on the life estate deeds and paying the property transfer tax at the time of the sale, at the time of the death, or excuse me, and the transfer, rather than at the time of signing the life estate deed. I still think it undoes that, but at least we eliminated what was an 8-year limit to get a refund from the tax department if for some reason the sale falls through or the transfer falls through.
Senator Shears, I have a question for you, as it sounds like you kind of, well, I know that you have some personal experience with this. So is the finance amendment to go back to what we're doing now and tax someone at the time of the life estate deed, even though that sale might, or that transfer might not ever happen?
Yes.
Why? That seems like terrible policy. Why would you pay taxes on something that you haven't actually received?
Exactly. Because
like, I don't understand why we would support that.
Well, because the tax department came in and said that they couldn't deal with it, they wouldn't know, they blah, blah, blah. And all the things that they said when we passed it out of here, they came in and convinced the majority of the finance committee. And if you know you're going to lose, at least get a plan B.
All right, well, I'm going to stay with you on the floor. I'm going to be voting no on that. You're right.
Well, thank you, but I'm going to be voting yes on the amendment.
You are, but I'm going to vote no for you.
Thank you. Anybody else who wants to weigh in on that is welcome to do so. Just so you're aware, it's coming up, and I reached an agreement with Senator Cummings because we had to get the bill out of finance and it was going to stay there over the life estate deed. Now, the other problem is the other body is continuing to screw up the forensics issue. And Senator Lyons is trying to work with the House on that. There are provisions in the bill that the House doesn't like on the forensic facility. And the other issue is S-150. They want to do that was the auto insurance bill, and they want to do a study by DFR, which would probably come back and say, leave things as they are. And so I'm not backing down on that at this point. Is there anything else that I've missed, Eric?
No, I think that's it. I think those are the two outstanding points that you just mentioned from the House perspective. And I did hear, and I'm not sure why, that Senator Probst wanted to look at it today, and I don't know why, but did you hear?
I don't know either. Right. I don't have any idea what they would be looking at.
Neither.
Well, and the House is going to ask for a conference committee on S-58. And so Senator Hashim, if you would be kind enough to let Senator Bruce know that I would like as the conference committee myself, you and Senator Norris.
Sounds good.
I would love to have Senator Wachowski, but she voted against the bill, and I don't think she should be on the conference committee.
Although I did learn that that is not required to vote for the bill. It's just by matter of tradition. Well,
yes, it is a tradition. One time we actually appointed somebody that was not on this committee to a conference committee because the Republican at the time would have wanted to go much further than even the Senate went. And we were concerned about what she might do on the conference committee.
In some states, I think Michigan is one of them, they actually require that an opposition voice be on conference committees, that someone who voted for it and someone who voted against it be represented.
I'm not changing that.
It's
that
okay,
tradition at this
I'm
point.
okay with that.
Senator, can I have one question, just about the,
Yep.
about the amendments? So I get that, so you got some that are on the calendar today, and I think the two that you're talking about this morning, the crack cocaine one, obviously is good to go, just with the additions of yourself and Senator Hashim. So, and then we've got this report one that, is still yet to be crafted. Is the idea that these two would be, it's on.
Well, I think my guess is that that Senator, if okay with Senator Vahowski, if the bill comes up, that she would offer the crack cocaine and then before third reading, offer the report language if she's okay with it.
Yeah, I'm okay with that. I
So
will connect.
I would suggest we strike that second, that the amendment strike if okay, strike that section dealing with the reports on forfeiture, and then offer an alternative amendment before third reading. So if you could draft that for the calendar or for the Senate as well, Eric.
Yes, definitely. So if for some reason they, I don't know, take it off the notice calendar today, I'll send you the other one, the crack one, shortly, so that if, and I don't know that they would do that, but just in case they do, so you could offer that one on the floor if you wanted, with yourself and Nader and Senator Hashim and Senator Sears.
Okay, sounds good.
That's-
Who knows what's gonna happen?
Right. Better to have it just.
End times.
Right.
So Senator Sears, are you offering the amendment on 233 on the floor today?
Yes.
Thank you.
Okay. I know Ben's been waiting on, is that it for Eric? I don't want to hold him up.
I think so.
Okay.
Thank you.
I believe Ben Novogowski is still waiting. And
Here.
Ben Dorback sent you copies of the House changes to the Superfund bill.
Yes.
And I think if you have time to go over them, I think you'll find that they're minor.
I printed you all out the official version that they passed. I'm gonna also email you a highlighted version that Michael Grady sent me that has like the changes specifically evident. So just look out for that in your email.
Okay. Senator Sears, you'd like me to proceed?
Yes, please. And I've got to take a short break. I'll be right back. But you go ahead. You go ahead.
Yeah, we still.
Oh, we still won't have
Yeah, we
quorum
lost
because
quorum.
Bob left. I was gonna try to
Senator
connect
Norris
with, Commissioner Morrison about what she was comfortable with going in this, well, we're gone, we lost quorum.
Yeah, so,
So, sorry.
it's okay, let's take 5.
On the floor in 15 minutes.
Yeah, and I have 40 pages of the bill to go through.
Yeah, we can